Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thank you as always for joining us. A lot to talk about. New developments in the Biden raid on Trump's home. A major court loss again for the Biden Justice Department. The court's appointed a special master. I'll give you the details there. Judicial Watch was able to help in the extraction of new information about the Obama IRS scandal, which of course was the prelude to all the other government abuse we saw in 2016 and beyond targeting Trump. And plus, we have new documents out of Boston showing that critics of the mayor were targeted with criminal prosecutions in a way that weren't provided for by law. So a lot to talk about there. Plus, it's the 10th anniversary of Benghazi coming up, and I want to get back to the truth about Benghazi that the media is continuing to cover up and explain Judicial Watch's key role in exposing that terrible, terrible scandal. First up, though, is the developments out of Florida in the case concerning Joe Biden's political raid on Trump's home. I mean political in the sense that it had no lawful basis in my view. As I've described to you before, the President of the United States, when he's president, has the ability to denote records as presidential records versus personal records. And that means he can also, and separately, declassify any records he wants. And the prior Justice Department position had been, and we know this for a fact because Judicial Watch was involved in the case, it was a case over tapes in Clinton's sock drawer that he kept that concerned recordings of his talking to foreign leaders and other sensitive topics that were presumably classified. And we thought maybe, hey, doesn't the PRA cover that? And the Justice Department said, nope, if he takes them with him when he's out of after the presidency, they're presumably personal. So why did they change the rules for Trump? So when you hear noise that these records are classified in government records, the Justice Department is being dishonest. They're being dishonest with the American people and, in my view, the courts. And the courts, I believe, know something's up. And indeed, Judge Cannon in Florida, who has been handling President Trump's request for a special master and other relief, seems to be suspicious of the Justice Department. And the Justice Department lost hugely earlier this week when the judge issued this ruling granting President Trump's request for a special master. Now, of course, the left is outraged that a judge, let alone a judge appointed by President Trump, made this ruling because the left doesn't believe the president has civil rights. The left doesn't believe the president should get the time of day from the courts because they hate Trump and they don't believe all the protections available to any other citizen, and particularly to any other president, should be available to President Trump. Well, the court begged to differ, and the court, I think, exposed the corruption of the Justice Department, albeit in a nice way. I've got the decision here, actually. And for instance, according to the Privilege Review Team's report, now supposedly the Justice Department had a Privilege Review Team look at documents before the investigators at the FBI were able to look at them. The seized materials from President Trump's home included medical documents, correspondence related to taxes, and accounting information. So the Justice Department is telling the court that Trump has no interest, property interest in these documents, and the court's saying, what are you talking about here? The government has also acknowledged that it sees some personal effects without evidentiary value, and by its own estimation, upwards of 500 pages of materially potentially subject to attorney-client privilege. So, and the court also explained in her ruling that the Justice Department confessed to her that some attorney-client protected material did make it through the filter team and was seen or made available to people who shouldn't have seen it. And so what the judge wants is a special master to reassure the American people that justice is being fairly administered. And she defends the court, the president, you know, that she highlights the consequences to the President Trump, if these records that they really have no right to are misused. he faces potential harm by way of improper disclosure of sensitive information to the public. Further, plaintiff is at risk of suffering injury from the government's retention and potential use of privileged materials in the courts in a process that so far has been closed off to the plaintiff and that has raised at least some concerns as to its efficacy, meaning the process that the Justice Department has instituted that has no outsider making sure they're doing the right thing vis-a-vis President Trump. So the government has made the argument, the Biden administration, that President Trump had no interest, no possessory interest, the technical term I think is, in these documents, that were either classified or government records and such. And the court said, no here. I mean, there's an issue about what these documents are and who they belong to. So your conclusion doesn't necessarily mean that that's the end all and be all here. And of course, in none of these proceedings, as the government admitted, that there's this other court ruling in the Judicial Watch Clinton sock drawer case in which they took a completely different position with respect to presidential records, where the court, in a decision that the Justice Department and Archives wanted, said the Archives has no business demanding any records, can't second guess the president's determinations. I mean, how does that fit in with what they're doing here? And the court also found that there is potential executive privilege the president can assert here. And so there has to be a special master who can look at this. And the court enjoined the Justice Department from using any of these documents in its investigation. Now, the Justice Department's outraged at that because it means their whole sham attack and continued abuse of Trump has to stop for now, in part, at least in a way, in terms of any official investigation. And this is what the judge found at the end. The court is mindful that restraints on criminal prosecutions are disfavored, but finds that these unprecedented circumstances call for a brief pause for a neutral third-party reviewer to ensure a just process with adequate safeguards. So the judge shut it down, and both the Justice Department and President Trump and his team have to propose ideas for special masters and how they're going to operate. It should be they should be filing it any minute now. I've been half jokingly saying that Judicial Watch should be the special master. You can probably trust Judicial Watch as much as anyone to look at this material fairly. But in many ways, a special master under the Justice Department's initial theory of how presidential records are supposed to be handled really doesn't have much to do other than to make sure that all the records that they took are turned back to Trump. Because as I said, all those records are President Trump's personal records under their theory of the law and under the Presidential Records Act. So that to me is kind of where the rubber ultimately ought to meet the road, whether the president's team makes that aggressive argument or not. And I don't think it's aggressive. I think it's just asserting the facts and the laws the Justice Department has previously told the courts. I don't know whether that's going to happen or not, whether those issues are going to be joined. But there has to be a reckoning for this raid on the president's home that resulted in the retention of documents they had no right to by their own admission. And sure enough, in the filing that they've made, threatening the court, saying, you need to stay your ruling because we want to still look at these records, they tell the court that no matter basically how the court rules, they're going to appeal by September 15th. So without even having read how they handle how she handles their motion to stay, they're going to appeal, which is the height of arrogance. And similarly, the day after, by the way, the court complained about essentially the leaks and the appearance of bias in this process and how Americans need to be reassured by the appointment of a special master. The Justice Department leaks out to the Washington Post a document from the raid. So this is the arrogance. And they show contempt for the court, whether it's technically legally contempt of court, that's another matter. But this is contempt for the court, contempt for the rule of law. You see it in this filing they made where they're essentially telling the judge, we don't care how you're going to rule. how well considered it is. We're just going to appeal it, which is, in my view, inappropriate. And secondly, they admit and they confess that there are personal documents they're going to return to President Trump. So again, none of this is voluntary. Remember, when Judicial Watch fought successfully to get access to the warrant and to the affidavit, which was redacted, but we got a lot of information out of it. Remember, the Justice Department, the Biden Justice Department, wanted not one word to come out, but we beat them. And in this case, President Trump beat the Justice Department. So you've had two courts on this sensitive matter basically tell the Justice Department, we don't buy your legal arguments and we don't trust you to do right by President Trump. And of course, the media won't talk about it that way, but Judicial Watch will. So you've got the Justice Department coming in, though, just even after they get slapped back by the judge, telling the judge, we don't care what you think, we're going to appeal it. Of course, they have a right to appeal, but you don't tell a judge, it doesn't matter how you're going to rule, we're going to appeal. I mean, that's inappropriate and shows contempt, as I say, for the prerogatives of the court. And then secondly, they confess they have to turn documents back over to President Trump. And then they say, well, we didn't read your ruling to stop us from leaking this garbage to the House and the Senate, the supposed congressional authorities with oversight over intelligence. You know who that means? Adam Schiff. So the court says you can't use these documents, and then they go and tell the court, well, by the way, that doesn't mean we can't give it to Congress. Talk about contempt for the rule of law. So this is what this is about, and it further confirms that this was a political operation. They went into the president's home to find dirt, to leak to the media, and to leak to their friends in Congress in the days before an election. And hopefully get an indictment out of it, either of people close to Trump or Trump directly. All of this tied in, again, to President Biden's red speech and his vicious attacks on any American who dares support anyone other than him and his policies. I mean, you combine that with the raid on Trump's home and this abuse of power. You see Steve Bannon now being targeted by New York Democrat politicians, perp walked in front of the media like it's not even third world. It's worse than that. In banana republics, they don't pretend to be anything other than they are. Here they pretend to be something more significant, that we follow the rule of law. In a banana republic, people say, well, obviously we know what's going on. Here we have the media and the president's echo chamber online and elsewhere in the establishment pretending that all this activity is legitimate. They're lying to the courts. They're abusing authority. As I say it, they're abusing the use of force. When the FBI raids a home, their ability to do that is, you get out of our way, otherwise you'll be arrested or worse. I mean, they use force. That's the reality of it. Now, does it mean that anyone was forcibly moved? No, but they rely on their ability to use force to enter someone's home, to, quote, execute a warrant. And it was for political purposes. It wasn't for legitimate law enforcement purposes. And they're still lying, in my view, to the courts about it all. So we'll see what's going to happen. And the irony is, I think it's an interesting question legally, isn't it? Whether a president can take documents with him, anything he chooses, practically speaking, when he leaves the White House, whether or not that necessarily becomes personal. I mean, we thought it was an interesting question. That's why we sued over what Bill Clinton had done. And we were told, nope, you're wrong, Judicial Watch. But what we don't like, it's not an issue of transparency. It's a question of whether the law is going to be fairly administered. There's this little phrase in the 14th Amendment called equal protection of the law. President Trump is not being given equal protection of the law. He's being targeted in violation of Justice Department positions, in violation of court decisions related to presidential records. And I would refer you back, if I could repeat myself, but I think it bears repeating because no one else is talking about it, to the corrupt Attorney General Garland, who said, typically we try to do something short of a search warrant. Well, so that admits that this was an atypical activity. Typically, and this is a big deal, we typically try to have a narrow search. And the mirror of that is this was a fishing expedition. It wasn't a narrow search as the Fourth Amendment requires. The president is a crime victim. His civil rights are being abused 6 ways to Sunday by this Justice Department and FBI. It's been going on since at least 2015. And it shows no sign of stopping. And there are people who are happy to see it, and frankly, there are Republicans who are happy to see it because of policy differences and personality differences with Trump. And my view is, and Judicial Watch's view is, this is a rule of law question. If we're going to abuse people because you don't like their politics or policies by using the powers entrusted to officials by the American people, boy, all bets are off when it comes to our Republican form of government. And as we see with Bannon, it's being expanded. It's being expanded to abuse other individuals. Bannon's being abused. Those who dare to question the 2020 elections are being abused by not only the January 6th Rump Committee, but by the Justice Department. Now they're investigating Trump's fundraising. So you've got essentially the political party of Joe Biden basically acting through the Justice Department, investigating the fundraising of their opponents, the Republican political party. In this case, specifically Trump's individual PAC. Outrageous. Based on this idea that, he said he was going to do work against for clean elections, raising money for clean elections. They wanted to know whether he kept his promises. Who are they kidding? It's completely a politicized investigation. So things are getting worse. So the Justice Department is likely going to appeal. We don't know what's going to happen with the special master. I don't think Judicial Watch is going to get appointed a special master. So the battle will continue, and Judicial Watch is going to be in the forefront. We already have one lawsuit. We filed successfully a request for information to get this material unsealed, and you can bet more lawsuits are coming. Well, I told you a few weeks ago that there was a big transparency ruling in Obama IRS case that we had participated in, and the ruling was going to require the disclosure and the unsealing of the deposition transcripts of Lois Lerner, who you all know about, and another woman who you may not know about, Holly Paz, P-A-Z, and both of whom were in the middle of the Obama IRS suppression of the Tea Party. Also, other documents were released because there were documents that relied on that deposition testimony that the parties had filed that were also unsealed. And it's a big deal. And the documents further confirm the abuse of the Tea Party, the knowing abuse of the Tea Party, and a cover-up of that abuse. The documents were unsealed in a case that happened out in, I think it was in Ohio, the NorCal Tea Party Patriots versus the Internal Revenue Service. The records were back from 2017, and the court outrageously had been sitting on it for 4 years. The court wasn't ruling on the effort to unseal this. So the plaintiffs, if I recall, sort of mandamus of the court, meaning they asked the appeals court to say this judge needs to act. This is not right. So the judge finally just ordered the release of the records. The sworn depositions, as I say, were given in 2017 by Lerner and Paz, and the two IRS officials repeatedly have memory lapses in the depositions, which is, par for the course, and regularly plead ignorance about the fundamental matters that they were being paid to handle on behalf of the U.S. taxpayer, meaning the efforts to stonewall, and in many ways harass those seeking 501c4 applications approval from the IRS. Now, 501c4 is a type of IRS organ, it's a definition that the IRS uses to define what is called social welfare organizations. And these are groups that can involve themselves in politics much more than a 501c3 can. Like, they run ads usually about attacking politicians or raising issues. They can't necessarily say vote for or against someone, but they can get much more political. Judicial Watch, for instance, is a 501c3 educational foundation, so we can't do those types of ads by law. And back in 2010, when this scandal first started, there was this big decision out of the Supreme Court the left went crazy about, essentially affirming the First Amendment, called Citizens United, which allowed for much more participation by Americans in the political process. And the left obviously doesn't like that for reasons that we can spend a lot of fun explicating, but I'll leave it for you to understand that instinctively. And so not being able to get the feds by law to restrict free speech, they used the IRS as a backdoor way to suppress these groups that were trying to assert their First Amendment rights. Now, you may, those of you who are students of politics closely, you may remember that the Tea Party emerged around the beginning of the Obama administration, and their activism, which was anti-government spending, generally opposed to Obama administration policies, helped result in a big win for Republicans in 2010. So what happened to the movement in 2012? Everyone said, what happened to the movement? Well, it was suppressed by the IRS. So this was a massive suppression of the Tea Party in a way that benefited, not coincidentally, President Obama's reelection campaign. So we know what I love about Mitt Romney, by the way, when he poo-poos President Trump's concerns about the abuse of him in 2016, it's like Romney is not self-aware enough or doesn't know enough about the way things operated to recognize that he was also abused when he was running against Obama, because they were targeting people likely to be supportive of him and to be active on behalf of his issues in the election campaign. It was election interference as much as it was election interference when the FBI and DOJ were harassing and spying on Trump, and when they were suppressing Hunter Biden information in 2020. So you had the IRS doing that work for Obama in 2012. That's why they did it again in 2016, because with the abuse of the FBI and DOJ, because it worked. So these are all the records we got. It's 500 records. And they include the deposition transcripts, and these are what the transcripts look like. And I encourage you to read them all, because I'm not going to be able to, in the brief time I have, to describe all the good stuff in here. But I encourage you to read the Holly Paz deposition transcript. You'll see it easily available. I encourage you to read the Lois Lerner deposition transcript. It'll take a few hours to read it, but I read it. So if I can read it, you can read it, right? And also, I encourage you to read, shortly after the transcripts, it's a big file, 500 or so pages, essentially what the plaintiffs allege based on the evidence in terms of the misconduct of the IRS in the abuse of the Tea Party and their clients. And it's called the Plaintiff's Statement of Material Facts in Response to IRS Statement of Proposed Undisputed Facts. So that's a technical way of saying this is our story. And so it describes quite succinctly and effectively the corruption behind this unprecedented abuse of the IRS by President Trump or his appointees. and in league with Democrats in Congress to target their political opposition. So some of the details include in Holly Paz's deposition, the one that I noted is that one of the big lies they put out there is the reason they couldn't deal with all of these Tea Party applications because they were overwhelmed by the large number of them. Well, that was a lie. Holly Paz's deposition shows that the reason they didn't handle these Tea Party applications is because they had one application initially that they thought was important vis-a-vis the Citizens United case, meaning they were hesitant to apply it because they didn't want these C4 groups to operate. So they stalled on handling this one application, and they were depending on that analysis to handle all the other C4 applications. So it wasn't because there was this large number and they couldn't deal with it. No, they didn't want to approve any of them. And that's confirmed in this deposition. Also confirmed, Holly Paz acknowledges that the applications as they were made to the IRS required them to approve them, that there was no basis to not approve them. Question: the organizations had filed applications representing what they were organized for and what they have done and also their intended activities. And you thought that for the majority of those applications, that would warrant the recognition of exemption, meaning application approved. The witness, Holly Paz. My recollection is that at the time, my thinking was that the majority of the C4 applications, while they may have indicated some amount of political activity, that we would not have had enough basis to make a determination that would be their primary activity and deny them exempt status. And therefore, they would receive an approval or recognition of exemption. Correct. There you have it. They knew they had no basis to deny these applications approval. Instead, they stalled and delayed and stonewalled and harassed them with questions about what books they were talking about at their meetings and other irrelevant information. Also information about their donors. They had no right to get information about the donors in the way they were asking, and they acknowledged that in these documents that I'm talking about here. I encourage you, because they don't want you to know about this. It took us 4 years to get access to this. And you'll see why, because it confirms, as I say, the Obama administration was the most corrupt administration in American history. Although now I have a caveat now, but Biden still has a few years to go, right? My joke about Biden is that he's the most corrupt president since he was vice president. And you'll see why here. So I encourage you to look at this material. So as I say in the release, these new transcripts expose new details and, of course, more information about the cover-up on how the Obama IRS intentionally suppressed the Tea Party movement during the 2012 presidential campaign. These documents show how the Obama administration easily used the IRS to suppress an entire political movement threatening his re-election. The Obama IRS abuse is the epitome of election interference. Given this largely unchecked abuse by the IRS, meaning Lerner was never prosecuted, no one was ever prosecuted for this. The Biden administration's massive new expansion of the IRS should concern all Americans. They're hiring upwards of 80,000+ people. They've increased the IRS budget by $80 billion. I just threw my paper away. I didn't mean to do that. Sometimes I get so angry I start throwing paper away before I am done with it. And so this IRS continues to be a sword of Damocles over your First Amendment rights. I mean, I just told you about the dishonesty at the highest levels of the IRS. This went all the way to the top. And we expect the same agency, who hasn't been punished at all for this, and especially with President Biden talking about how evil all his political opponents are, threats to democracy. How do you think the IRS is going to handle an audit if they think you're a threat to democracy? So these are dangerous times, and I encourage you to look at Judicial Watch's work in this area. We cover it in our book, I think, Clean House. The detail on the IRS scandal is amazing because, as I said, Judicial Watch was doing all the heavy lifting, I shouldn't say all of it, most of it, in getting information out about what was going on. We found out, for instance, the FBI and the IRS were working together to try to jail the heads of these groups, even though they hadn't done anything wrong. We found out that you had even people like John McCain encourage the IRS to abuse their powers to target their political enemies. So this was a bipartisan issue in some ways. I mean, people forget that just because it's a Democrat administration or Democrats that are targeting conservatives, that all Republicans are against that. No, 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 no. There are many Republicans who hate the conservative movement and are happy to see it destroyed. There are many. It's happening with Trump, and it happened with the IRS. The proof is in the pudding. They didn't impeach the IRS Commissioner Koskinen, the Republicans. I mean, they weren't interested in it. It's a tacit approval of the activity, in my view. Of course, not all Republicans think that way, but I think a lot of the leadership does. And Judicial Watch was getting all of this information out because Congress wasn't doing the work. I mean, there was missing emails that we uncovered. It was like Hillary, there was a Hillary Clinton type scandal in the IRS. Emails got deleted, or they said they were deleted when they actually weren't deleted. All that we uncovered. I mean, they were getting information about donors. They acknowledged they were getting information about donors after denying they were targeting donors. And they acknowledged the information wasn't needed. I mean, I remember one document that really got me angry is that they were concerned that these groups were complaining to Congress, right? And so I don't think it was Holly Paz. It might have been Cindy Thomas, who was another IRS official. You can Google it. And it should pop up vis-a-vis Judicial Watch's website. And the IRS official says, well, I'll just send these groups more questions so they'll get distracted from telling Congress, complaining to Congress. I mean, completely lawless basis for asking anyone. It's kind of like an audit. You're filing an application, you're getting audited. And the irony here is that these were conservatives, right? And so they were doing what they thought the laws required. The irony is they didn't need to file applications. C4-hour organizations could just start operating. They didn't need to file an application. All they needed to do was start filing IRS 990s IRS forms once they started operating. But because they wanted to play, dot every I and cross every T, they did what good law-abiding people do, which is they followed all the rules, even the rules they didn't need to follow. And they got slammed. So again, all of these documents are available on our website. You can go to judicialwatch.org. We'll probably have a link or two below so you can look at the material yourself. But this is one of the most important scandals in American history, or one of the worst. And if you want to know what Lois Lerner didn't want to say under oath, or what she avoided saying under oath, or what she was forced to say under oath, you'll want to see this. And I think Holly Paz's deposition transcript is probably even more important than Lois Lerner's in confirming this outrageous IRS abuse that was completely lawless, and the IRS has been held not accountable yet, other than through Judicial Watch's exposing what went on, and so it will remain a threat to our freedoms. When you see this, you're going to say, whoa, we got still a lot of work to do when it comes to the IRS. And believe me, we haven't given up on the IRS generally in terms of oversight. And you can bet there's going to be more coming from Judicial Watch on IRS accountability, especially as it expands its intrusion into our lives. So we had a little interesting lawsuit in Massachusetts, in Boston, Massachusetts, that uncovered documents showing that they were the Boston police, seemingly at the urging of political officials in Boston, were concocting ways to arrest people criminally for protests outside the mayor's home that could only be punished civilly. So Mayor Wu, who is the new mayor in Boston, I don't know how new she is. Maybe she was elected last year, 1 year or 2 years. So she's a big leftist, and she had come up with this draconian COVID-oriented restrictions, which required people to show proof of COVID-19 vaccinations to enter certain indoor spaces, including indoor dining, fitness, and entertainment venues. And so protests began outside her home shortly thereafter. The Boston City Council then passed an ordinance. This began in January 2022. So it shows you how outrageous those regulations were. I mean, you know, the idea that you would have COVID shutdowns and restrictions in January 2022 is just absurd. So there were protesters outside her home. So the Boston City Council then passed an ordinance that prohibited and enforced with civil fines protests outside residences during certain hours. I think it was 9 p.m. to 9 a.m. On April 25th, 2022, a woman, Shannon Llewellyn, was arrested outside the mayor's home and criminally charged for violating the ordinance that only allowed for civil enforcement. Sure enough, on September 6th, just last week, or I guess this week, Boston judge later ruled that Llewellyn was wrongfully arrested. So we saw this was going on, and we asked for documents. We got the runaround from Boston, and we wanted records concerning the enforcement of that ordinance. Now, personally, and I'm sure you probably share my personal views, I don't have objections to restricting protests in residential areas to be either enforced with civil fines or potentially criminal sanctions. But here the law only allowed for enforcement with civil sanctions. But that wasn't good enough. And the documents show that the police were thinking of ways. The City Council adopted the law on March 30th, and what they tried to do was come up with this way of getting people arrested criminally for it. Because I guess they were politically embarrassed by having to arrest people, at least on the surface, so they thought of a backdoor way to do it. And the way they thought about, and the way they constructed, as these documents show, was that they say, well, you know, the first time you get a civil enforcement, a civil fine potentially, the second time you're going to be charged with a willful violation of a civil statute. Now, does that sound like, catch-22 to you? It does to me. And it obviously did to a court who found that someone arrested under that rubric was wrongfully arrested. So, I mean, this shows you the hypocrisy of the left in Boston. They don't respect the First Amendment, and they don't respect the rule of law. Because by limiting it to civil fines, they're telling people, potentially, I guess you can protest, but there's going to be a civil penalty if you break the rules. Instead, they made it much riskier to protest in that regard by imposing arrests and criminal sanction in a way the law didn't allow them to do. And we confirmed that in these documents. So it's really quite remarkable what we were able to uncover here. And it's clear that the courts didn't want, or the police didn't want, civil enforcement. They wanted criminal enforcement of this. And when you're talking about the police, I'm talking about the chief and captains, people at the senior levels who are involved in this. The first set of emails comes from a then police captain. A lieutenant is quoted here. The police captain is obviously managing this. The internal affairs division's involved in this. So this had all the bureaucracy involved. So they're remarkable documents in that regard. And what I think is interesting about this is how quickly the left is willing to go after someone out protesting outside a leftist home, right? Up in Boston, the mayor. While you have federal law that specifically prohibits, through criminal sanction, protests outside the home of a Supreme Court justice. And this Justice Department refuses to enforce that law. They'll raid someone's home, President Trump's home over empty folders, as I like to say, because they found empty folders, right? That was outrageous. They were empty folders. There could have been classified information in those empty folders. But they won't protect the Supreme Court justices who are being intimidated by radical leftists. But in Boston, you complain about masks and COVID, you'll be fined, and they'll think of ways to criminally arrest you even if they don't have the law on their side there. That's today's left. It shows you the double standards. It shows you the fact that the rule of law is misused to apply to only one political outlook. And we can't stand for that. And we have to expose that corruption and end it. And we're not going to end it unless we expose it. And that's what Judicial Watch is doing, obviously with your support. So that was a nice little victory in terms of getting that information out. And we hope the courts go to town now by protecting people from this lawlessness up in Boston, to protect Mayor Wu from getting too much in the way of protests over her draconian COVID policies. I also want to talk about Benghazi because we're coming up on the 10th anniversary of Benghazi, September 11th, 2022. Obviously the same date as the 9/11 attacks. Now, when Benghazi happened, any sensible person would have thought that it had something to do with 9/11. Well, not if you were in the Obama administration, because they didn't want a 9/11 style attack. In this case, it killed our U.S. ambassador to Libya and 3 other innocents on the eve of their election. So they lied about it. They said it had nothing to do with terrorism. It was in response to a video that was allegedly offensive to Muslims, and that was a lie. And Judicial Watch alone exposed it was a lie by getting documents from the Obama White House and the State Department and such showing that they knew it was an attack from the get-go. They stalled on sending help. All of that information Judicial Watch was unable to cover. Virtually everything we know about Benghazi that's important, Judicial Watch uncovered through its litigation and investigations. And including, through the course of that investigation, we uncovered Hillary Clinton's emails. So because of the Benghazi cover-up, we fell upon Hillary Clinton's emails. So the Benghazi, in many ways, led to the uncovering of Clinton's emails, the scandal associated with that. In her emails, we also found information about the play-to-pay scandals that she was involved in with the Clinton Foundation and the State Department, all of which helped contribute significantly to her loss for the presidency. And we didn't do it to make sure she didn't become president. It wasn't an election issue, but that was the consequence of our disclosures. So Benghazi is a big deal, and it continues to be a big deal because we still have officials who lied about it in positions of public trust. Obviously, Biden is president of the United States. His top domestic policy advisor is Benghazi Susan Rice. She was then UN ambassador. Hillary didn't want to go out there and defend Benghazi, so they had Susan Rice go on all the 5 Sunday morning talk shows and lie about it being a terrorist attack. Lie about it being not a terrorist attack, I guess I should say. So Jake Sullivan, also a Clinton aide, he is the national security advisor for Joe Biden. And of course, you see this in Afghanistan with our surrender there. You have them lying about the circumstances of that surrender and how it happened and what happened and the suppression of information. It's Benghazi to the nth degree. So I don't know about you, but Benghazi is never going to go away for me. And there are 4 Americans who are dead. They didn't have to be killed. Meaning that their deaths could have been averted if the Biden administration, the Obama administration wasn't playing games in Libya, which was basically turning Libya into a way station for arms, it looks like, to support their war in Syria, which included arming terrorists. We had documents showing that the Obama administration knew about and was in a position to stop, in the least, arms going out of Benghazi to the war theater in Syria. And that whole mess was created because of the instability in many ways. All those terrorist regimes, all those terrorist groups that started emerging beyond Al-Qaeda, like ISIS and groups like that, was because of the instability created by what happened in Libya with the removal of Gaddafi. That led to Benghazi, and it led to the war in Syria that saw the United States support terrorists. Just incredible. All of that uncovered through Judicial Watch's litigation. Obviously, 9/11 is a significant anniversary because of the 2001 terrorist attacks, but don't let the media bury Benghazi, because Benghazi is about Obama, it's about Hillary Clinton, their misconduct, and it's about the misconduct of key officials in the Trump administration, in the Biden administration. Jake Sullivan, Susan Rice, and of course, the president himself. I'll share some links below to some of our key Benghazi materials, but I encourage you to read up on what we found on Benghazi, because it will just knock your socks off. Well, the terrible news this week is the death of Queen Elizabeth II. She was obviously a wonderful figure, a worldwide figure. She'd been queen for 70 years. What I found especially noteworthy about her was her sense of ethics, her sense of nobility, her sense of morality. She was obviously a Christian woman. The media doesn't want to really talk about that, but she was a God-fearing woman. And one of Judicial Watch's missions is to promote ethics and morality in our nation's public life. We want people to be honest. We want them to be ethical. We want them to be moral. We want them to, defend the system as we understand it, our Constitution, and protect our government and our rights and our freedoms, and love our country. And she was a great example of that, at least in the context of her own great nation. And we would do worse than to have politicians try to follow her example. So obviously, our condolences to her family and the people of the United Kingdom, but there are a lot of lessons to be learned worldwide from her reign and the wonderful way in which she conducted herself throughout her public life. So with that, I send you out to read all the material I've talked to you about. Look at those IRS documents. Look at those filings in the Trump in the Trump case. They're all available online. Look at the documents we got out of Boston. And if you think that sort of work is important in terms of having it exposed, having Judicial Watch defend the rule of law against those who would destroy it, then I encourage you, after you look at all those documents and share them and spread the wealth and the education, support Judicial Watch with your most generous donation at judicialwatch.org. With that, I'll see you here next time on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.